did not follow the procedure provided in the condition of service for termination of employment for services no longer required. The defendant pleaded the fact that the employment of the claimant was terminated in compliance with the provisions of Section 16.6 of the Defendant's Staff Handbook and Condition of Service, and the claimant was also paid 3 months' salary in lieu of notice. The claimant did not file a reply and therefore did not controvert these averments of the defendant. I have seen Section 16.6 of Exhibit K. It provides that the defendant has the right to terminate the appointment of his staff by giving 1 or 3 months' notice or pay in lieu of notice if the services of the staff are no longer required. By this provision, it means the defendant can terminate the claimant's employment other than on disciplinary ground. The claimant pleaded Exhibit K as a condition of service which regulated his employment with the defendant. It is therefore clear that the claimant was aware that the condition of service vests the right on the defendant to terminate his employment if his services were no longer required. The claimant's employment was terminated with immediate effect on the date of the letter of termination. It means that the claimant was not given the required notice. What the condition of service required the defendant to do in that situation to make the termination valid is to pay 1 or 3 months' salary in lieu of notice. The defendant complied with the provision when it paid the claimant 3 months' salary in lieu of notice as shown in Exhibit N. In cross-examination, the claimant admitted that he received the sum of 525,994 naira in his account on 14 December 2021, and the alert described the payment as 3 months' salary in lieu of notice. It is therefore clear that the defendant relied on Section 16.6 of the Defendant's Staff Condition of Service to terminate the claimant's employment, and it complied with the requirements of the Condition of Service as to payment of salaries in lieu of notice. In view of the foregoing, I hold that the claimant failed to prove that due process was not followed in the termination of his employment by the defendant. It implies that he failed to show how the termination of his employment is unlawful or void. In my view, the defendant terminated the claimant's employment in accordance with the provisions of the Condition of Service which regulated the claimant's employment. The result is that there is no merit in this suit. The suit fails completely and it is dismissed. Parties shall bear their respective costs. Judgment is entered accordingly.
We thank my noble Lord for this.
Thank you.
My Lord, the place. We are grateful.
Thank you. So you will get your judgment later today to be sent. It will be brought for my signature, and then you will. Thank you.
I'm most grateful.
Thank you. Mohammed, call the next case.
Let's remind ourselves that 9/2023, Mbelu Arize Justin and Camilo A. Umodike. Lord, parties absent.
My Lord, the plaintiff is present.
Please.
Yeah, my Lord,
Okay.
the plaintiff is present and online.
My Lord, the defense is also present.
So all the parties are present.
Yes, my Lord.
Yes, my Lord.
Thank you. Appearances.
With profound respect to this honorable court, my name is Ezenwa Angomno.
Appearances, please.
Yes, my Lord, profound respect to this honorable court, Ezenwa Angomno,
Yes.
and my humble appearances for the plaintiff who is in court. May my noble Lord be pleased.
Yes.
Humbly, my Lord, Ocholi Okutepa.
Anumno is A-N-U-M.
Anumno is A-N-U-M-N-U, my Lord.
Yes, yes.
ANUMNU.
Appearance is for the claimant.
Yes, my lord.
Thank you. Yes, please.
Humbly, my Lord, Ocholi
Yes.
Okutepa. Ocholi is OCHOLI, O initial,
Yes.
Okutepa, OKUTEPA.
Yes.
My humble appearance is for the defendant.
Thank you. So I'm going to proceed to deliver the judgment, and I'll be reading directly from my system. As much as possible, I will read it. I will abridge it. Reading in everything is already contained in the body of the judgment. By a complaint filed by the claimant on 14th March 2023. He commenced this action where he claims against the defendant as follows. There are 15 claims, and I have listed them out. I have also summarized the case of the claimant and that of the defense, and the written addresses have been touched upon. I will then proceed to the decision part of this judgment. Reliefs 1 to 7 sought by the claimant are declaratory reliefs, while reliefs 8 to 14 are claims based on the success of the declaratory reliefs. In view of the claims of the claimant, the issue I will determine in this suit is whether the claimant has proved his claims and entitled to the relief sought. The determination of his employment is in breach of the contract of employment and therefore invalid, wrongful, and unlawful. Then in relief 8, the claimant sought an order setting aside the termination of his employment. Relief 5, 7, 12, and 14 are also claims connected with the declaration sought in relief 1. I will therefore examine these claims together. Before I consider these claims, it is necessary to point out that from the employment letter of the claimant and all other employment documents the claimant tendered in evidence, and all other employment documents the claimant tendered in evidence. The employment of the claimant with Arik Air was a master and servant employment. In such an employment relationship, it is settled that termination of the employment, no matter how wrong, cannot be declared invalid or null and void. See Esevere versus NEPA 2002, Eze versus Springbank PLC 2012, Uzondu versus UBN PLC 2008. Once the employment of master and servant is terminated, the court cannot set it aside or make an order that the employment still subsists. Where any of the parties in master and servant employment have exercised his right under the contract to terminate the employment, whatever perceived defect exists in the manner of termination of the contract only renders the termination wrongful, but the employment remains terminated. The instance where a termination of employment can be declared null and void or that the employment still subsists is in respect of the employment regulated by statute. Therefore, given the nature of the claimant's employment, reliefs 1 and 8, where he sought that his employment be declared invalid and be set aside, are dead on arrival. The only part of relief 1 which needs to be considered is whether the termination of the claimant's employment was wrongful. It is the law that an employee who brings a case for wrongful termination of employment must, in order to succeed, plead and prove the following essential facts: the terms and conditions of his appointment, the circumstances in which his appointment can be terminated under the condition of service, the procedure stipulated in the condition of service for termination of the employment, and the manner in which the termination breached the said terms and conditions of his appointment. See Petroleum Training Institute versus Matthew 2012. See also WAEC versus Oshonebo 2007. This requirement of the law is applicable in all cases, whether it being master and servant employment or employment protected by statute, in which the employee complains of wrongful termination of the employment. See AG versus Child Basin Development Authority 2016. Accordingly, the primary duty placed on the claimant who is seeking that the termination of his employment be declared wrongful or unlawful is to plead and prove the terms of his employment and show how the terms were breached when his employment was terminated. In his pleading and evidence, the claimant said by a letter dated 28 January 2021, Arik Air Limited, the claimant's former employee, terminated his employment and by the terms of his contract of employment as contained in the letter of appointment, he is entitled to a 3-month salary in lieu of notice. This is all that the claimant pleaded and said in his evidence with respect to the termination of his employment. From all that the claimant pleaded, what I observe is that his claim for wrongful termination of his employment is based on his allegation that he is entitled to 3 months salary in lieu of notice. The claimant did not plead or mention in his evidence that he was entitled to notice or to a specific period of notice. He did not also aver that he was not given notice of termination of his employment. He simply said he is entitled to 3 months salary in lieu of notice, without giving the background facts which entitled him to his claim for salary in lieu of notice. Although in paragraph 9 of his statement of facts, the claimant pleaded that his letter of appointment contained the clause which entitled him to 3 months salary in lieu of notice. I cannot find any term therein which entitled him to 3 months salary in lieu of notice. The term in the appointment letter relating to notice of termination of appointment provides for 1 month notice of termination after the period of probation. What this means is that in lieu of notice, 1 month salary is required to be paid. Exhibit ARIC 7 is ARIC Air Condition of Service for pilots and engineers. The claimant tendered this document in evidence. In paragraph 1.08 of the claimant's final written address, Learned Counsel referred to clause 22B of the exhibit and submitted that this document forms part of the contract which regulated the claimant's employment. What Learned Counsel for the claimant tried to put forward in his submission is that the claimant's entitlement to 3 months salary is based on clause 22B of the document. First, this argument conflicts with what the claimant pleaded in paragraph 9 of his statement of facts, where he averred that he is entitled to the 3 month salary by virtue of the terms of appointment of his appointment letter. Second, the claimant did not plead ARIC Air Condition of Service for pilots and engineers as the condition of service. What the claimant pleaded as containing the condition of service, particularly with respect to his entitlement to 3 months salary in lieu of notice, is his appointment letter. See paragraphs 8 and 9 of the statement of facts. The claimant did not plead or rely on any other document as containing the terms and conditions of his employment. Third, even if exhibit ARIC 7 can be examined, plus 22B of the document relied on by counsel for the claimant does not support the claimant's assertion that he is entitled to 3 months salary in lieu of notice. Clause 22B of Exhibit 7 provides that period of notice for confirmed employee is 1 to 3 months or 1 to 3 months salary in maybe you call her your cousin. Maybe they just. In other words, the party deciding to terminate the contract is given the discretion to give notice of termination salary for the same number of months the party deems fit as notice period. By clause 22B of Exhibit 7, ARIC Air is permitted to decide to give notice of 1 month or 2 months or 3 months. It also means that ARIC Air is entitled to decide what to pay as salary in lieu of notice. Accordingly, the claimant cannot rely on Exhibit RX 7 to found his claim of being entitled to 3 months' salary in lieu of notice. The claimant contended in his reply to the statement of defense that he was not given notice of termination and he was not paid salary in lieu of notice. In the statement of defense, the defendant pleaded that the claimant was informed of the termination of his employment in a letter dated 28 January 2021. And in line with the contract of employment, the claimant is entitled to 1 month notice or salary in lieu of termination of his employment. The defendant averred further that the claimant received more than his 1 month salary at the time of termination of his employment. From the averments of the defendant, it is apparent that the claimant's employment was terminated without giving him the required 1 month notice. That was why the claimant was paid salary in lieu of notice. The letter of termination of the claimant's employment, Exhibit RX 3, is dated 28 January 2021. The claimant's employment was terminated with effect from 31st January 2021. The letter was made only 3 days before the effective date of the claimant's termination. The claimant's appointment letter requires 1 month notice of termination after the period of probation. By this term of the contract, in lieu of the notice, 1 month salary is required to be paid. The claimant was not given 1 month notice. Therefore, Arik Air was required to pay 1 month salary to the claimant, which the defendant said Arik Air paid to the claimant after the termination of his employment. In cross-examination, the claimant confirmed that he received the sum of 1,952,123 naira 20 kobo from Arik Air in February 2021, but there was no explanation as to what the money was for. The claimant has now been told that the money was meant as salary in lieu of notice. From the foregoing, the claimant was entitled to 1 month salary or 1 month salary in lieu of notice to terminate his employment. He was accordingly paid 1 month salary in lieu of notice after the termination of his employment. The result is that the claimant did not prove that his employment was wrongfully terminated. The implication of the foregoing findings is that the claimant has failed to prove release 1, 5, 7, 8, 12, and 14. Another aspect of the case of the claimant is his claim for payment of arrears of his salary in the sum of 8,886,000. In his evidence, he said upon his promotion to first officer by his former employer in March 2018, his monthly salary was 1,053,000 naira. His former employer did not pay him salary for the months of May, June, and July and 2020, and for the months of August, September, October, November, and December 2020 and January 2021. He was paid the sum of 240,000 naira in each of these months. His outstanding balances for each of the months of August to December 2020 and January 2021 is the sum of 813,000 naira. Hence, he sought in relief 2 a declaration that he is entitled to the payment of the arrears of salaries owed to him by his former employer in the sum of 8,886,000 naira. And in relief 9, he sought an order for the payment of the said amount. The claimant pleaded that the amount of his monthly salary in paragraph 6 of the statement of facts and his averment was admitted by the defendant in paragraph 1 of the statement of defense. Also, the fact that the claimant was not paid salaries for the months of May, June, and July 2020 was pleaded by him in paragraphs 10, 11, and 12 of the statement of facts. In paragraph 4 of the statement of defense, the defendant denied the claimant's averments and stated that due to COVID-19 pandemic in the year 2020, all staff remained at home due to the lockdown, except where some staff were required for operation of charter. The defendant, however, did not aver that the claimant was paid salary for the said months or that the claimant was no longer his employee in the period. Furthermore, the claimant pleaded the facts of payment of the sum of 240,000 naira as salary to him from August, September, October, November, and December 2020 and January 2021 in paragraphs 13, 14, 15, 16, 17, and 18 of the Statement of Facts. The defendant admitted the averments in paragraph 5 of the Statement of Defense and added that as a result of the pandemic, staff of Arik Air who remained at home did not receive salary, but after resumption of flight operations, only a 20% discretionary pay was made on monthly basis to staff, including the claimant. From the pleading and evidence of the parties, these facts are not in dispute. The claimant's monthly salary was the sum of 1,053,000 naira. 2. The claimant was not paid salary for the months of May, June, and July 2020. 3. The claimant was paid 240,000 naira salary for the months of August to December 2020 and January 2021. In view of the in view of the agreed amount of the claimant's monthly salary, was underpaid salaries in the months of August to December 2020 and January 2021 to the tune of 813,000 naira per month. The defendant gave reasons to justify the non-payment of salaries to the claimant for May, June, July 2020 and payment of 240,000 salary to the claimant from August to December 2020 and January 2021. The excuse of the defendant is that all staff remained at home due to the lockdown during COVID-19 period, and Arik Airline had financial challenges during the period. The defendant also explained that it was when flight operations resumed in 2020 during the COVID period that it decided to pay what it called 20% discretionary pay to staff, including the claimant. One of the terms of the contract of employment between Arik Air and the claimant is payment of salary to the claimant on monthly basis and by the terms of the contract in Exhibit Arik 2. The amount of the claimant's monthly salary is specified. In accordance with the contract, the claimant was being paid the sum of his monthly salaries from March 2018 up to April 2020, when Arik Air suspended payment of salary to the claimant. And then from August 2020, started to pay the claimant reduced salary up to January 2021. When the claimant's employment was terminated, the payment of the salary in Exhibit Arik 2 is an agreement between the parties and it is binding on the parties. The claimant was still an employee of Arik Air between May 2020 and January 2021. His employment was terminated only on 31st January 2021. Although it cannot be denied that there was a period of lockdown during the COVID-19 pandemic and it caused financial difficulties at the time to lots of businesses, this did not affect the terms of the contract between Arik Air and the claimant. Inasmuch as the employment contract subsisted during the period, the claimant is entitled to be paid their agreed salaries. The defendant relied on the difficulties and absence of the operations caused by the pandemic to absolve Arik Air from liability, but Arik Air never declared redundancy in that period. It would have been more prudent for Arik Air, who could no longer pay salaries to staff as a result of the pandemic, to declare redundancy and terminate the employment of staff it could no longer accommodate, rather than suspending payment of salaries to its staff for resorting to payment of percentage salary. In my view, suspending payment of salary or payment of part salary to an employee while the employment subsisted leaves the unpaid salaries to be paid in arrears and therefore a debt recoverable from the employer. What's up, Paul? Mom, one side. Princess. The explanations given by the defendant to justify non-payment or payment of reduced salary to the claimant by Arik Air is not tenable and cannot avail the defendant. It is the responsibility of the defendant to pay all the arrears of the claimant's salaries in the period the salary was suspended and the period was paid part salary up to the date of termination of his employment. I therefore resolve and hold that the claimant is entitled to be paid all the salaries he was not paid from the months of May 2020 to January 2021. The amount claimed by the claimant as arrears is the sum of 8,886,000 naira. From the evidence of the claimant, he was not paid salary in those months. In view of the amount of the claimant's monthly salary pleaded in paragraph 6 of the statement of fact, the 3 months unpaid salary amounted to the sum of 3 million, that is the months of May, June, and July 2020, amounts to 3,159,000. Again, the outstanding part of the claimant's salary in each month from August 2020 to January 2021, which is a period of 6 months, is the total amount of 4,878,000 naira. I find that the total amount of salary arrears of the claimant from May 2020 to January 2021 is the sum of 8,037,000 naira and not 8,886,000 naira, which he claims in Relief 9. The claimant also sought to be paid salary bonus for 13th month. This claim is contained in Relief 3 and 10. In Relief 3, he sought the court to declare that he is entitled to the sum of 480,000 naira, being salary bonus for 13th month, which his former employer did not pay to him when his employment was terminated. Then in Relief 10, he claims the said sum of 480,000. In defense of his claim, the defendant pleaded in paragraph 6 of the statement of defense that 13th month bonus was paid to staff who were recalled to work, and since the claimant was not among them, he was not entitled to 13th month bonus. What the claimant said in establishing the claim is that his former employer did not pay him salary bonus for 13th month, and he mentioned the sum he ought to be paid to be the sum of 480,000. Before the court can find the defendant liable for not paying the salary bonus for 13th month, the claimant has the duty to first prove that he is entitled to payment of salary bonus for 13th month. The claimant did not tell the court, whether in his pleading or evidence, how he became entitled to the payment of salary bonus for 13th month. He also did not show how the sum of 480,000 naira emerged as the amount of the salary bonus. I have seen the claimant's appointment letter dated 9th March 2015, which is Exhibit ARIC 1, containing the agreed remuneration of the claimant at the point of his appointment. His remuneration and benefits did not include salary bonus for 13th month. I have also seen the claimant's promotion letter dated 6 March 2018, which specified the claimant's improved salary and allowances on account of the promotion. This is Exhibit ARIC 2. It also did not include salary bonus for 13th month as one of the claimant's entitlements or benefits. I have carefully considered the evidence adduced by the claimant, but I find that he failed to prove his entitlement to payment of salary bonus for 13th month. Accordingly, the claimant failed to prove Reliefs 3 and 10. The claimant also claims payment of his pension. He averred that during his employment, the sum of 72,000 naira was deducted from his monthly salary as his pension contribution, while Arik Air contributes 90,000 naira monthly to his pension. This makes his total pension contribution payable to his RSA by Arik Air to be. However, for the months of April 2020 to January 2021, while Arik deducted his pension contributions from his salary, it failed to remit the monthly pension in the sum of 162,000 naira into his RSC. The sum of 1,620,000 naira is the total unremitted pension of the claimant for the period. Based on these facts, the claimant sought a declaration that he is entitled to the sum of 1,620,000 naira as unremitted pension entitlement for a period of 10 months, and an order for the payment of the sum of 1,620,000 naira to him reliefs 4 and 11. In paragraphs 9 and 10 of the statement of defense, the defendant pleaded that since there was no salary payment to staff of ARIC during the period, other than the 20% discretionary pay, there was no pension remittance for the claimant and other staff. By this argument, the defendant has admitted that ARIC did not remit any pension for the claimant within the period from April 2020 to January 2021. During my consideration of the claimant's claim for payment of arrears of salaries, I did find that salary was not paid to the claimant in the month it was paid to him from August 2020 to January 2021. Since salary was not paid to the claimant in May to July 2020, pension could not have been deducted from the unpaid salary, while they were paid from the paid claim in August 2020 to January 2020.
My lord, we cannot hear you anymore.
Yes, I lost you for a moment and I'm back. My
August
internet was
2020.
unstable.
Okay, my lord. My lord, we were
Yeah.
at August 2020 to
Where
January
was I?
2021. You were talking about the pensions, my lord. August 2020 to
Okay.
January 2021. That's where you were, my lord.
April 2020.
Okay.
So yes, the claimant averred that ARIC contributes the sum of 90,000 naira monthly to his pension. The defendant did not dispute this averment. Thus, the defendant is liable to pay ARIC's contribution of 90,000 naira monthly for the claimant's pension for the months of April 2020 to January 2021 into the claimant's RSA. The claimant also claims payment of 3 months pension for the period he thought he ought to be given notice of termination of his employment. In the first place, the claimant was not entitled to 3 months notice. Thus, he cannot seek to be paid pension for the period he was not entitled to notice. In addition, the claimant's employment was terminated with salary in lieu of notice. He is therefore not entitled to pension after the termination of his employment. For these reasons, reliefs 6 and 13 lack merit. After a careful examination of the claims of the claimant in line with the evidence adduced by him, I find that he failed to prove reliefs 1, 3, 5, 6, 7, 8, 10, 12, 13, 14, and 15. These claims are accordingly dismissed. I find for the claimants in reliefs 2, 4, 9, and 11, and I grant the claims in the following terms. 1. It is declared that the claimant is entitled to payment of the sum of 8,037,000 naira, being arrears of his salaries from May 2020 to January 2021. 2. It is also declared that the claimant is entitled to the sum of 900,000 naira, being the total sum which ARIC ought to contribute to the claimant's pension, but which were not remitted to the claimant's RSA for the period of April 2020 to January 2021. 3. The defendant is ordered to pay the claimant arrears of his salary in the sum of 8,037,000 naira. The defendant is equally ordered to pay the sum of 900,000 naira into the claimant's RSA with Leadway Pension Limited. These sums must be paid to the claimant within 30 days from today, and failure to do so, the judgment sum shall attract 10% per annum, 10% interest per annum until the time it is paid to the claimant. Parties shall bear their respective costs. Judgment is entered accordingly.
As court pleases.
As court, please.
Please.
My Lord, on
Okay.
behalf of the claimant, I wish to thank my Lord for the time, the thoroughness, and the industry that my Lord has invested in this judgment. We're
Thank you
grateful.
very much.
Yes, my Lord, we are grateful for the judgment, and we will like to thank my Lord again for the sense of justice. May my Lord be pleased.
Thank
Well,
you.
On our part, we are grateful for the well researched. It was like sitting in a proper class and taking some lecture. Thank you for thorough decision. We are grateful. Thank you, my Lord.
Thank you.
Next number, NSCN/ABJ.
My Lord, I would just ask, sorry, my Lord, I know you want to call the next matter. In view of the time we have to comply, we are hoping that we can get this. My friend is laughing because we can get the judgment today or tomorrow, so that we can communicate with our clients immediately.
I'm not sure if my Lord is
Yeah,
online.
I think the network issues. Yes, please.
So do I say, okay, my Lord is back.
Okay, my Lord is back. Yes.
Yes, I'm back.
Okay, yes, my Lord.
I'm waiting for Mr. Mohammed to call.
Okay.
Yes, I'm listening to you.
Okay, no, I think my Lord heard me. Your response appears to address the issue already.
So today or tomorrow?
Okay.
Yes, my Lord.
Yes, as soon as I'm done, I will send the judgments to them so that it can be printed, and they will bring they'll bring them back for my signature, and you can have them immediately.
Thank you, my Lord. We are grateful.
We are grateful, my Lord.
Thank you. Thank you. You're welcome. Is Mohammed in court?
Yes, Lord.
Can you call the next case, please?
This number, NSCN/34/2023. Nigeria Army. The present
Are the parties present?
Yes, my Lord.
The claimant is present?
Yes, Lord.
Okay. Claimant present.
Absent.
Defendant? What about defendants? Defendants absent. Appearances, please.
May it please your Lordship.
Yes.
Anuwe Joseph.
Anuwe Joseph.
Oh,
Yes.
my humble appearance, my
Yes.
Lord, for claimant who is in court.
Any appearance for the defendant?
Respectfully, CM Okosa. My Lord, my humble appearance is
Please
defendant.
just give me a second. Paper query me. Well, I need paper. Kenny? Just a minute, please. I have a problem. I don't have paper.
Okay, my Lord.
Okay, yes, I'm with you. Appearance for the defendants.
Respectfully, my lord, I am
Yes.
CM Okosa. My lord,
CM.
Okosa. OKO.
OKOSA.
My lord, my appearance is for the defendant.
Thank you. Thank you very much. I'll proceed to deliver the judgment. And as usual, I will introduce it. The claimant instituted this action on 23rd August 2023 via a complaint wherein he sought the following claims. He has listed 8 claims there, and I will not bother to read it out. I have also summarized the case of the claimant and that of the defendants, as well as touched on the final written addresses of the parties. I'll go straight to the decision. It is not in dispute that the claimant was an employee of the first defendant and he was dismissed from service. From the evidence of the claimant, he was dismissed from service on 18 June 2021 after appearing before the trial officer, commanding officer for trial on 3 count charge offences alleged against him. The first claim of the claimant in this suit is for the court to declare that his dismissal from service by the defendant is illegal, null and void, having been done in breach of the provisions of the 1999 Constitution and the Armed Forces Act. In reliefs 5 and 6, the claimant sought that his dismissal be set aside and he should be reinstated back to the service of the first defendant. I will first consider these claims of the claimant concerning his dismissal from service. In his evidence, the claimant narrated on 18 June 2020, he went to fetch water for use when one Captain Abubakar came and ordered him to close the tap. He obeyed and returned to his post. But later that day, he was summoned to the battalion headquarters, where he was told verbally that he is to appear for battalion commander's orders. He was tried on a 3-count charge, bordering on disobedience to particular orders. Although he was not given a copy of the charge sheet, the charges were read over to him during the trial, and he pleaded not guilty to all the charges read over to him. The offences for which he was tried were never investigated in accordance with laid down procedures. And no witness was called to testify in proof of the charges against him or to refute his claims. When he was explaining the circumstances of the incidents between him and Captain Abubakar, the trial officer, who was also the commanding officer of the unit, told him he was lying and ordered the RSM to march him out. After the trial, commanding officer to trial officer orally announced his dismissal to him, and he was marched off to be detained in the Sector 2 Provost Company guard room until 8 February 2021, when he was dictated and sent away. In response to the averments of the claimant, the DW stated in his evidence that the claimant was arraigned on 4-count charge offences. A copy of the charge sheet was given to the claimant and its content read out to the claimant at the commencement of the trial. Before the arraignment of the claimant, a proper investigation was carried out and a properly constituted panel adjudicated on the matter. The claimant was afforded the opportunity to defend himself and he called 3 witnesses to testify on his behalf. The panel found the claimant guilty, after which the claimant was dismissed from service. In employment cases, it is settled law that where an employee complains of unlawful termination of his employment, the employee, in order to succeed in the claim, must plead and prove the terms of his contract of employment, how the employment can be terminated under the condition of service, and the manner the terms of the contract were breached by the employer when his employment was terminated. In WAEC versus Oshonebo 2007, it was held that an employee who brings a case for wrongful termination or dismissal must, in order to succeed, plead and prove the following essential particulars. 1. The terms and conditions of his appointment. 2. The circumstances under which his appointment can be terminated or dismissed under the condition of service. 3. The procedure stipulated in the condition of service for termination of employment or dismissal. And 4, the manner in which the termination or dismissal breached the said terms and conditions of his appointment. See also Ante versus University of Calabar 2011, Oloruntoba Oju versus Abuja versus Chad Basin Development Authority 2016. The Supreme Court held that whether one is suing for wrongful dismissal from an employment with statutory flavor or under common law principle of master and servant, the fact of the employment and the terms and conditions of same must not only be service himself as the evidence adduced by him. In his entire pleading and evidence, the claimant did not mention the condition of service which regulated his employment while in the service of the first defendant. He did not also plead the procedure prescribed in the condition of service to be followed before an officer can be dismissed or terminated from the service of the first defendant. The claimant alleged that he was not given a copy of the charge sheet. The offences for which he was tried were never investigated in accordance with laid down procedures. No witness was called to testify in proof of the charges against him, and that his dismissal was communicated to him orally. He also said the trial officer descended into the arena, gave evidence, and arrived at a verdict based on his own evidence. Having said all this, the claimant did not show that these acts violated any provision of the condition of service. In other words, the claimant did not link the allegations he made against his dismissal to any condition of service. Although the claimant asked the court in Relief 1 to declare that his dismissal was done in breach of the provisions of the Armed Forces Act, he did not show in what manner his dismissal violated the provisions of the Armed Forces Act. The claimant did not plead or prove the procedure provided in the Act for termination of employment of officers of the first defendant. He also failed to plead or prove any provision of the Act that was breached or violated by the defendants during his dismissal. I have observed that the complaints of the claimant against his dismissal are rather about breach of his right to fair hearing during the trial, resulting to his dismissal. He, however, failed to show that his allegations of denial of fair hearing are based on breach of any provision of the condition of service which regulated his employment. The claimant cannot rely on breach of fair hearing alone to challenge his dismissal without linking the breach to the terms and conditions of his employment. See Aji versus Chad Basin Development Authority, SUPRA. Thus, it is the law that the issue of fair hearing or lack of it is tied to proof of the terms and conditions of service of the employment. Therefore, in the absence of proof of the dismissal being in violation of the terms of the employment, reliance on breach of fair hearing alone cannot sustain the case of the claimant. The result is that I find that the claimant has failed to plead and prove how his dismissal breached the conditions of service of the Armed Forces Act. He also failed to link the allegations of breach of fair hearing to breach of the terms and conditions of employment. Let me add that the claim in Relief 1 is a declaratory claim. The claimant did not adduce cogent and credible evidence in proof of the claim. Consequently, I find that the claimant failed to prove the declaration he sought in Relief 1. The implication is that Reliefs 5 and 6 sought by the claimant also fail. In paragraphs 23, 26, 27, 28, 29, and 49 of the statement of facts, the claimant pleaded that after he was informed of his dismissal by the commanding officer, he was taken to Sector 2 Provost Company guard room and detained. He was detained in the guard room from 18 June 2020 until 1st February 2021. He said his detention for that length of time was ultra vires the powers of the trial officer. During the period of his detention, he was subjected to performing all manner of odd jobs, like cutting of grasses and sweeping of the compound. He was also used as batman to the RSM of Sector 2 Provost Group to wash the RSM's clothes, cook for him, and wash his car. He was also made to work on the farm of the commanding officer Sector 2 Provost Group, Colonel M.M. Husseini. On 1st February 2021, he was released from Sector 2 Provost Company detention and handed over to his unit 134 Special Forces Battalion RSM. The unit RSM further detained him in the unit guard room from 1st February 2021 to 8th February 2021, when he was declared and sent away. He further pleaded in paragraph 49 that the illegal and lengthy detention which he suffered and the slavish servitude to which he was subjected constitute breach of his right to liberty and dignity of his human person. On the basis of these facts, the claimant sought in reliefs 3 and 4 declarations that his detention after his dismissal and the servitude he was subjected to while in detention constitutes violations of his rights to liberty and to dignity of the human person. While in relief 7, the claimant sought an order directing the defendants to pay the sum of 100 million naira as exemplary, aggravated, and general damages on constitutional breach of his fundamental human rights. In paragraphs 14, 17, and 28 of the statement of defense, the defendants aver that they are not in a position to admit or deny the averments in paragraphs 24, 25, 27, 28, 29, 47, 48, and 49 of the statement of facts. It is settled law that where a defendant pleads not in a position to deny or admit specific averments in the statement of claim, the defendant is deemed to have admitted the averments. See Oseni versus Daodu, 1994, Idris versus ANPP, 2008. Accordingly, the defendants are deemed to have admitted that after the claimant's dismissal, he was put in detention in Sector 2 Provost Company guard room until 1st February 2021, when he was released and handed over to his unit, who further detained him until 8th February 2021. The defendants also admitted that during the period of his detention, the claimant was made to cut grasses, sweep the compound, used as batman to the RSM of Sector 2 Provost Group, wash the RSM's clothes, cook for the RSM, wash the car of the RSM, and work on the farm of the commanding officer. The defendants also admitted that the claimant's detention was illegal and lengthy, in which period his right to liberty and dignity of his human person were breached. In view of the admission of these facts by the defendants, the claimant is taken to have proved his averments. Let me add that the punishment given to the claimant for finding him guilty of the charges against him was the dismissal. At the moment the claimant was dismissed from the service of the first defendant on 18 June 2021, he ceased to be an officer in the service of the first defendant, and he cannot thereafter be subjected to service discipline or the condition of service in the first defendant. See Nwankwo versus Nigerian Army 2021. Thus, since he was no longer in the service of the first defendant from 18 June 2021, there was no justification for his detention by the defendants for 8 months. The claimant's detention after his dismissal and subjecting him to degrading treatments while in detention was wrongful and a breach of his right to liberty and to dignity of his human person. I find that the claimant has proved the declarations he sought in reliefs 3 and 4 and is accordingly entitled to compensation for the breach of his rights to liberty and to dignity of his human person. After considering the claims of the claimant, I find that the claimant failed to prove reliefs 1, 2, 5, and 6. These claims are dismissed. I, however, find that the claimant has proved reliefs 3, 4, and 7, and they are granted in the following terms. 1. It is declared that the detention of the claimant after his dismissal was illegal, ultra-vires the powers of the trial officer, and constitutes a breach of his fundamental right to liberty. 2. It is declared that slavish servitude to which the claimant was subjected by the servants of the defendants while in detention constitutes a gross violation of his right to dignity of the human person. 3. The defendants are ordered to pay to the claimant the sum of 10 million naira as compensation through damages for the breach of his fundamental human rights. Cost of 500,000 naira is also awarded in favor of the claimant. The orders made in 3 and 4 above must be complied with within 30 days from today, failing which the sums will begin to attract 10% interest per annum until they are fully paid up. Judgment is entered accordingly.
As per places.
My Lord, we are
I don't open.
Thank you.
we thank
Thank you. So you get your judgments later today, or as you liaise with the registrar. At worst, you get it tomorrow, but you could get it today if you wanted. Thank you very much. That will be all for today.
Yes, my lord.
Enjoy the rest of the day because
Thank
we
you, my lord.
rise.
God.
Thank you. Thank you.